This is the next blog in a series about a federal case under what's called the Federal Tort Claims Act, where a baseball injury was sustained by a young man who was watching older people play at a U.S. Army National Guard outing. This is something I'd like to blog about because I am a huge baseball fan, and I also have an interest in the law and in tort law, negligence law. And the judge who decided this case, I recently testified in the case I've blogged about involving excess insurers suing the underlying insurer. Given that my case was a negligence case, I was very interested to see what this judge would do with this negligence case, that is the baseball case. You may recall the facts from the last blog. The young man was walking towards home plate by the third base line as a play was unfolding, and the catcher was going to throw to third and regrettably hit this boy in the head, and the boy suffered significant head and brain injuries. Now, as the judge found in his facts, the young man was moving toward the third base line, but he was also walking past the supervisor of this event and was bending down as if to pick up a bat. Now, the supervisor is the one against whom liability was found, but because this is against really the United States government and the United States Army, the supervisor did not have to pay any judgment, but the United States surely has or will have to as a result of this decision. Now, there were 4 allegations of negligence, and the one that the judge found really would permit negligence was the second one, that the supervisor and other soldiers were negligent in allowing the child onto the field during active play. This is not a very young child, this is a 13-year-old. And the judge reviewed the law of negligence, that it requires, by a preponderance of the evidence, the finding of a duty of care. Secondly, that there's been a breach of that. And thirdly, a relationship, a causal relationship between the breach of duty and the resulting injury. This game was actually a spontaneous softball game. A more formal game had taken place that morning. But because it was spontaneous, there was no allegation that would, in the judge's mind, that would work against some of the higher-ups in the military. It was only against one particular person who was there kind of supervising the game. Now, personal injury cases that rely or that come about from an athletic event in Massachusetts have to really satisfy a recklessness standard. Now, interestingly, the recklessness standard was not met as against the catcher. There was a claim against the catcher for his negligence, but the judge said no. However, a lesser standard, that is a negligence standard, was asserted against the person who was in charge. And there, in that case, the judge found that that lesser standard of negligence was met as against that other individual. Again, that other individual was not the catcher who was throwing to third, but rather was a gentleman who was in a supervisory way. And the judge said, in contrast to the catcher, so-and-so's potential liability is based not on his participation as a player, but rather on his overall responsibility as the senior officer on site at the Family Day event to avoid exposing attendees to foreseeable and unreasonable risks of harm. In other words, the theory of liability asserted against that senior officer in charge is the familiar one in premises liability, and one I've spoken about, and that is a person in control of premises has a duty to avoid exposing those persons on the premises to an unreasonable risk of harm. The judge found that this officer, the senior officer in charge, because of his supervisory responsibilities, had a duty to protect the young man who was injured, as well as others, but they weren't injured, from foreseeable risks of harm. And thus, when the boy sort of wandered onto the field and was hit, the judge felt that the supervisory officer was more interested in the game than in the safety of bystanders, which was his responsibility. The judge made note of the fact that the supervising officer was yelling to the catcher, the play is to third, the play is to third, instead of his being concerned with the young man who was walking toward the catcher and ultimately was hit. Thank you.